But our first speaker today is attorney Erica B. Rogers. Now, she's with Ward & Smith, and I'll tell you, she has some great information about the copyright issues, because if you are picking up pictures from the internet, from wherever, to support your website, to support your PowerPoint presentation, whatever you plan to use them for, not a good idea. And she's going to tell you why. So please welcome Erica.
Good morning, everyone.
Good morning.
I am overly caffeinated, so if I talk too quickly, just like raise your hands or something and tell me to slow down. And I also have so many things that I could talk about and not enough time. So I'll try to hit maybe the highlights, and if you have any questions, I'll stick around and you can talk to me afterwards. But the main thing, just to start out, and maybe this is obvious, some of the things I say to some people but not to others, so I think it's important, is just what is the difference between copyright law and trademark law in the broadest sense. And so copyright covers creative work. So that's going to be if you're on your social media sites or your website and you're posting text or pictures or anything that has a creative artistic component to it, that's where copyright law will come into play. Trademark law is going to be a word, a logo, or device, anything that you use to indicate to consumers that you're the source of a certain product or service. So when it comes to setting up your social media site or your website, it's important to understand how these different areas of law come into play, both on the defensive, to protect, because you're putting a lot of effort and work into creating your sites and your social media platform, that you want to protect and be defensive so that nobody steals your hard work, but you also want to make sure that you're not doing anything to infringe other people's work or other people's copyright, other people's trademark. So specific to social media, I think the first step that you would want to do, and I know that as an attorney, I don't even always do this, but you want to go in and read the terms and conditions, privacy policies, takedown procedures for all of the sites that you plan to use. So for Facebook, Twitter, Pinterest, go through, and those are the text that you go and click the box, and like I said, I know it's a lot to read, but it's really important that you know what those terms are and what you're agreeing to. And this was kind of mentioned earlier, but on the copyright side, you don't want to post any content that you didn't create on your website or on your social media site. And I know that the way that we live today, things are shared openly all the time. That doesn't mean that it's okay. So if somebody doesn't go after you for copyright infringement, it doesn't mean that you're not violating somebody's copyright. And you don't want to be in the position where you get a letter that you posted a picture on your website and you're violating somebody's copyright, because the amount of money that could be claimed as damages for that is really high, and it's not an area of law where your intent matters. So if you say, I didn't know that I wasn't supposed to do this, that doesn't matter. It's called strict liability, but it's going to be an issue whether you know it or not. So that's the first thing, and like I said, it's easy for images to become viral and people share them around, but if you're taking something that somebody else created and putting on your site, especially if there's a commercial benefit, so if you're selling a product or you're selling a service and you're getting that money and bringing people to your site to get that money by using somebody else's image or someone else's work, then you're profiting off of their independently creative work. So that's where the issue comes in, and that's where the law comes in. The other thing to do, so that's more on the don't take something from someone else, but for yourself, I think another thing I wanted to talk about today is just to be consistent. So a lot of times when we have clients that have a Facebook, they use LinkedIn, they have Twitter, their own website. It's important to be consistent with what your brand is and what you use as your trademark, because you're relying on that for consumers to know who you are. And so that can be adding an S to the end of the name, adding different colors, those kind of things. You want to choose one brand and put that the same way on each of your social media sites and on your website. So the same term, don't add different, and that can be different fonts, different colors. Just try to be consistent so that on your online presence and your online brand, consumers can rely on the same brand regardless of the place that they're looking for you. I know I'm like bouncing between lots of different things. I just have lots to say that I wanted to make sure that I tell you before we get to questions. The other thing to do is balance your enforcement of your brand with marketing concerns. So it's easy, so if you're protecting your brand and you find that somebody else has stolen your work or stolen your brand or is using your trademark and you send them a letter, those can come online as well. So if you send a nasty letter to somebody, there's nothing stopping them from putting it on their Twitter, and that's going to hurt your brand. And we see that, and that's something that people don't often think about. And so anything that you put online, whether it's a Facebook chat or anything to your consumers, if you get nasty complaints and you're nasty back, or you send letters, all of that, everything you put online can come back and hurt you. And so being careful about monitoring and protecting your brands and, enforcing that, but knowing that that can come back and hurt you is a balance that we always have to strike. And that's, being nice. You don't need a lawyer to tell you to be nice, but just keep that in mind as well. Another little tip, so you're going to have people go on your Facebook or your Twitter, customers, and post content on those pages. And so it's a good idea to grant yourself permission to use those comments and that content. And so you can do that in your About section, on your social media sites, or on your website in your terms of use, so that you make sure that if a customer is going to come on your Facebook and say, I ate at this restaurant and the food was fantastic, all this content, post pictures of themselves eating at your restaurant, you want to make sure that if you use that and share it on another place, you have permission to do that. So granting yourself permission to use other people's content is another thing that comes into play that's important to remember. So it's not just protecting the stuff that you create, but protecting the stuff that other people create and post on your social media sites and your website. Another tip is controlling if you have employees. A lot of times we have clients that will have an employee set up their social media site in their own email, and down the line that employee no longer works for the company and doesn't want to give up the effort that they put into the social media site. So a way to avoid that is set up an email account that nobody has a personal access to, but it's just the company email account, and that email account is going to be associated with the Facebook, with the Twitter, with the website. And so everything is set up, owned by, not a real person, but an email account that's accessible by the company rather than an individual employee. And making sure that your employees understand all of these issues that could happen so that they're aware of it and they're careful about what they do on your social media site. Am I going way too fast? No? Okay. Okay. The other thing is called false association. So it's a great idea to get people to come and purchase your services or your products by saying something like, Michael Jordan ate here and he thought my food was great, or using other people's reputation or brands to draw consumers into your business. And that's not okay. So you're not allowed to create a false association, or the town of New Bern credited us as the best restaurant in town, or things like that, where you're using some other person, some other reputation, and using it to draw consumers to come to you is not permitted. Let's see. The other thing, and this can be tricky for people, is the notice symbols on the intellectual property side. So the difference between an R in a circle and the TM on the trademark side is trademarks are acquired based on use. So as soon as you start selling a product or providing a service under a certain name, you are gaining trademark rights. Whether you go to apply for that trademark or not, you're getting trademark rights based on your use, and that's called common law use. And so you're allowed to put the little TM, and it's encouraged that you do so that consumers recognize that as your brand. Next to the name of your company, the name of your product is the TM. The R in the circle is reserved only for registered trademarks. So you can apply for your trademark on the state level with the North Carolina Secretary of State that gives you rights for the whole state of North Carolina, or you can apply on the federal level that gives you nationwide rights. If you secure a registration through either the North Carolina, or through the federal, through the United States Patent and Trademark Office, then you can put the R in the circle. But those are the notice requirements on the trademark side. On the copyright side, you can put the C in the circle as soon as you create the work. So you don't need the registration to provide notice that you're the copyright owner, and you can put the year of when it was created. So that oftentimes you can put at the bottom of the website next to any artwork, versus the TM is next to the actual product name, the company name that you're using as your trademark. And like I said, you can't use the registered, the R in the circle, unless it's registered. A lot of companies like the idea of promotions and sweepstakes, and so post a picture of yourself eating at our restaurant and we'll choose a lucky winner to have a free meal. Those kind of things where you're promoting sweepstakes. There's actually strict regulations that surround what you're supposed to be doing for those to be legal. So you can't just, in the abstract, say, post a picture and we'll choose one lucky winner. You actually have to say the credentials of how you're going to choose that person. It can be either based on chance, or it can be based on credentials of, whatever the artistic, whatever they put behind the picture. But if you're going to do something like that, you can't just say, we'll choose somebody and not articulate exactly how you're going to choose them. Because there's, like I said, there's regulations that cover sweepstakes laws that you can get into trouble if you just do that in the abstract and don't follow the notice requirements of the rules surrounding how you're going to choose those winners. The other thing is online privacy rights. So privacy law is sometimes swept into the broader concept of intellectual property, but it's a separate area of law. When you're collecting information from your consumers, from your customers on your website, their name, their email, anything about them, and this is going, this is a very hyped area of law right now with everything that's going on, but you have to be very careful about how you store that information and what you do with that information. When you have a website, it's highly recommended that you have a terms of use, which talks about your terms for using the website and also a privacy policy, so that when anyone accesses your website and enters in their information, enters in especially any financial information, there's going to be articulated a policy on how you collect that information, how you store it, what you do with it, or more importantly, what you don't do with it to protect you from those areas of law as well. And I think that the last thing, and I can open it up for questions because there's probably going to be some easier discussion when there's questions, but the last thing is just to remember that anything online is going to be seen by millions of users, and I know that sounds obvious, but like I said, with the demand letters and the comments and everything like that, it's all going to be accessible and people can screenshot stuff, so there's no, once you post something, there's no turning back and taking it down and trying to recover from something. It's definitely going to be something that you and your employees should be very careful about, what you do online, what you post, and what you don't post. So, thank you.
It used to be with copyright law that if you created something other and you copyrighted it, you actually had to send it into Washington. Do you still have to do that?
So that's called copyright registration. If you want to file a lawsuit against somebody for violating your copyright, you need a copyright, you need a registration in order to do so. So it's important on that sense if you're going to enforce it, but your copyright attaches to your work at the moment you create it.
So it's not necessary. Can you do it after the fact if you see that somebody has used it improperly? You can then register and go?
You can actually, and this is recent, but if you have an application pending with the Copyright Office for registration, that's enough to then file a federal lawsuit. John?
So if someone writes a Google review for you, do you have to get a release from them to post it on your website, or because they put it out on Google, you can just take it and place it on your website?
On a Google review site?
Yeah, like if someone puts out a Google review for you, but you want to put it on your website.
That's when I would look into, and I don't know this off the top of my head, but look into what Google's terms of use are. So that person, when they posted that review on Google, they might have consented to allowing that to be then posted anywhere else, and that would be in the terms of use for Google. And if it is in there, which it probably is, then you're okay. But that would be my first step, is check when that person posted it on Google, did they, by posting it, consent to it being free for anyone to use? Another thing you can do too, and it depends on the person, but if they write something really positive about you, then maybe contact that person and just say, can I post this on my website? I'll give you a free lunch or something, and then that way you have their consent in an email or in a voicemail, and you don't even have to worry about getting into the nitty-gritty of what the law is.
Yeah, doesn't Facebook own everything that's posted on Facebook, all images, comments, everything?
It doesn't own it, but it has a license to it. So when you post it, it's free to do whatever it wants, and I know that that's kind of a gray line, but it doesn't outright own it. It can do, from what I remember, it can do what it wants, but that's within the platform of Facebook. So if somebody posts something on their profile and you want to share it on yours, within the Facebook, that moving around of images is governed by Facebook. It's when you take a picture off Facebook, you save it, and then you upload it on your website that you've done something that falls outside of what the Facebook terms of use are. And that's when maybe you could get into trouble, especially if you find a great picture that someone posted on Facebook, you're posting on your website and you're using it to draw in customers off of that great picture. And once, it usually takes that commercial benefit and that I'm making money under the copyright lens for it to become a problem. Versus when you're just on Facebook, it's like, this is fun, we're sharing pictures, I'm not making money off of this. Once there's that dollar amount.
Contacting Facebook and asking for the permission is like, talking about that first, I mean, that's not gonna happen.
No, they're not going to, I don't think they're going to respond. What they will do, and this is something that I don't think I mentioned, there's means of takedown procedures for these different social media sites. So with Facebook, with Instagram, with Twitter, instead of contacting the person directly that might have infringed your rights, you can go through Facebook and enter your name, your link, your trademark registration, and Facebook will then take it down for you. So there's that too, and I don't know if I mentioned that.
One more question, and then we're going to have to wait for the discussion. Go ahead.
If we put a product that we want to sell on our Facebook page, what do we have to do to get permission from those people?
A product of somebody else?
Yes, product we're going to sell. We can sell peanuts on our...
Have you made the peanuts?
No.
Or like, I'm going to Target and buying a bottle of Coke and then I'm posting it on my Facebook to sell it?
We're the neighbors with their logo.
Have
Will
they,
we get permission from them to do that?
from Hubs? Yes.
Okay. We've not done that in the past. I know we just put it on there because we assumed because we sell them, they would be happy about that.
Yeah, no, you should have their permission because you're using their
So
trademark
I
and their
get something
logo.
in writing, an email or something?
Yeah, it would be a permission to use letter would work, but it's really called a trademark license type thing.
We will have